The wire came down on the 21st. I believe the significance of the 24th was that was when the order was signed, and I think Mr. Newland's memo said the 24th, but it is the 21st, which is reflected in the order the court's looking at now.
All right. Court will sign the order at this time. I believe that deals with your motion to compel, Mr. Zellman.
May I address one more thing about the issue we were just talking about? There is obviously this new discovery from this lead that the state was alerted to last fall. We conducted this investigation and followed that investigation to its conclusion. That obviously has resulted in some new discovery in these wire calls, but I did want to let the court know, though there are a large number of calls that the defense, of course, wants to review, there are only, I was told, about 30-something calls deemed pertinent by law enforcement, and the state likely plans to only use maybe one or two at trial, and believes that the 2 months the defense had from the time it was discovered to the time of trial in June should be sufficient to prepare for that portion of the trial.
Do any of the calls that you intend to use from this recent investigation go to privileged matters or encapsulate calls with counsel?
Thank you. I wanted to address that. There are no calls that were recorded between the defendant, Donna Adelson, and attorneys in this case. I specifically asked the investigator about that before the hearing.
Mr. Zellman, you may continue with your argument.
Yes, Your Honor. The state has also not responded to our request to let us know if they've also been monitoring our attorney-client conferences at the Leon County Detention Center.
That's a no.
And although the state believes that we're going to have enough time, I calculated this. There are over 32 hours of calls that were captured on that wire. And given the amount of materials that we have just been handed, we have not had an opportunity to review even 2 hours of those calls up to this point. Your Honor, just because the state believes that there's going to be enough time for us to prepare, and it's not 2 months, it's more like 6 weeks. There's not enough time for us to analyze this new information, synthesize it, prepare appropriate motions. We've spent the last 3 weeks dealing with this as opposed to finalizing the motions in limine.
That is an important point you bring up. Essentially, between what has been recently investigated and what the charges have been of murder, solicitation, and conspiracy from the time your client is charged, there are essentially two different pots, if you will. For the motions that the deadline was today as to the murder, solicitation, and also the last count as well, are those motions completed?
No, Your Honor. We've only had an opportunity to finish 2 additional motions that have not yet been filed, and I have not had an opportunity because we had to adjourn Investigator Newland's deposition to finish the Frank's motion.
Right. So you are in fact asking for an extension on the deadline to file your motions.
We're going to need one in addition to the continuance. Yes, Your Honor.
Ms. Dugan?
If the court wants to give an extended motion deadline, we don't have any objection to that. We do object to a continuance of the trial and remain ready for trial.
What is the defense? Well, before I come back to you, Mr. Zellman, what is the prejudice that the state would suffer if the trial is continued, Ms. Dugan? Beyond just a mere objection.
We would not suffer prejudice, Judge. We're just ready for trial if it goes as continued.
Mr. Zellman, what would you be proposing as a date? And you also have to keep in mind, there's only so many points in the year a trial that could take either 3 weeks or more can be scheduled. And I assume you've discussed with your client if your relief is granted.
We have.
What that means.
We have, Your Honor. And frankly, without getting through all of this new material, it's hard for us to pinpoint exactly when. I mean, we're not going to sit around on our hands and do nothing. We have been diligently preparing, and we're going to continue to diligently prepare. Likely 2 to 3 months would be, I think, realistic. But again, until we get through all these new materials, it's going to be hard for me to say.
Right. Concerning the motion deadline, which was supposed to be today, we'll set a new deadline, particularly as to the counts that have already been a part of the indictment and have been charged all along. The murder, the conspiracy, the solicitation, the deadline for filing any motions relating to the existing charges will be May 16th. The motion hearing that was scheduled to take place on that day, we will reschedule at a later point. Court is going to reserve ruling as to whether the motion for continuance will be granted. The parties are to confer about any redactions that you believe would be appropriate to the filings for the expedited motion for continuance, the state's response, and also the defendant's reply, and the motion to compel discovery. Any other matters that we need to address before we finish up for today?
Your Honor, with respect to the motion to compel, the state has also not provided concerning the jailhouse informants. We've also moved to compel that material as well.
Give me a moment. I'm just going to bring up the rule. Said this is 1M, which subsection?
1BM.
1BM. Stugan, response?
I'm sorry, Judge, I'm having trouble getting on the Wi-Fi. Is there...
This is in the discovery rule under the prosecutor's discovery obligation. And I will quote from it.
Thank you.
Whether the state has any material or information that has been provided by an informant witness, including the substance of any statement allegedly made by the defendant about which the informant witness may testify, a summary of the criminal history record of the informant witness, the time and place under which the defendant's alleged statement was made, whether the informant witness has received or expects to receive anything in exchange for his or her testimony, the informant witness's prior history of cooperation in return for any benefit is known to the prosecutor.
Yes, sir. Thank you for that. I'm familiar with that rule, but just didn't know all of the different things I needed to show there. Some of that has already been provided through the recordings. However, as far as her history, any benefit, all of those things, we'll disclose that to the defense as soon as possible.
Please disclose it by Friday of this week by 5 p.m.
Yes, sir. And may I also ask about today is the discovery deadline, which the state is prepared to obviously comply with. As far as though now the order on the continuance maybe being later in the week, would it be okay if we had a discovery deadline of 24 hours from the order, or would you rather keep keep it for today.
Concerning, again, the charges that have always been in place, the murder, the solicitation, and the conspiracy, is either party seeking more discovery on those charges that has not already been addressed up to this point?
Judge, the issue with complying with today's deadline is we have spent the last 3 weeks dealing with these other issues. We have
Not the motions. I'm saying, are you seeking additional discovery on the indictment charges?
We are not going to be able to meet the deadline to provide the state with our discovery because we have been focused for the last 3 weeks on other issues.
Ms. Dugan?
The state can comply with the discovery today. I just didn't know if given the possibility of the case being continued later this week, if it were possible to have 24 more hours after that order came out. But if it needs to be today, the state can comply with that, and the state would hope that the defense can comply to or get discovery as quickly as possible to us.
Once a ruling has been made on the continuance of the trial, the court will also address any deadline for discovery as well. For now, please operate as if the deadline remains in place. Wait for the order.
And Judge, I just want to make it very clear, there's no way we're going to be able to get it done, even if we were to work straight through till midnight.
Again, Mr. Zellman, as to that, what can be filed, please do.
Yes, sir.
I will let you know once we have a motion, or excuse me, once the order is on the motion to continue, whether the deadline for everything else related to today's deadline applies as well.
Yes, sir.
We are in recess. For everyone on the Zoom, that is the end of the hearing today.